Before we begin talking about this issue, I need to talk about a separate issue, about something that just happened. Just I want to make to disclose to you all. On my way out of the court. On my way out of the courtroom to go talk to my clerks, I was walking down the hall in the back hallway and there's the jury room right here, and I was walking by the open door to the jury room. As I walked by the jury room, I made a sound of frustration as I walked by the door, which I can best reproduce. It was something like, as I walked by, and I happened to glance over. The jurors heard me make that noise, and I actually saw them laugh at the fact that as I walked by the jury room, I expressed a verbal sort of expression of some frustration, and they heard that and they laughed. I don't know what to make of that. I don't think it is any prejudice to either side. I can't imagine that they're going to infer from that anything in particular other than that the truth, which is I'm frustrated by the fact that, this is taking some delay to get this case moving, and that I was in my head thinking about these issues and trying to work through them. So I just raised that to your attention because it was a sort of brief quasi-interaction between me and the jury, which was totally unanticipated. I didn't know they were in that room. I didn't know the door was open when I walked by. Does either party want to say anything more about that or feel the need that we need to address that with the jurors? I don't think we do, but...
Well, I agree. I think that's probably the general consensus of everybody involved in the trial at this point. I don't think we need to blood here.
Attorney Sisti, do you have any concerns about that? And again, there was no words. I did not say any words. It was simply a sound that I made.
We're okay.
Okay. Going forward, I'm going to make sure that doesn't happen again. But anyway. All right. I've had the opportunity to review, particularly I reviewed State v. Warren, which is a case involving the completeness doctrine. And defense counsel is right that otherwise inadmissible evidence can be admitted under the completeness doctrine if it's necessary to prevent a party from gaining a misleading advantage. Under that doctrine, a party has a right to introduce the remainder of a writing statement, correspondence, or conversation so far as it relates to the same subject matter and tends to explain or shed light on the meaning of the part that's already received. Right? So that's the standard. I mean, Warren was a much cleaner case in that it involved a statement in which the defendant had made certain admissions, but as part of his statement, he mentioned the fact that there was one particular sentence, I think, about a knife that the state was trying to keep out, and the court felt it was unfair to keep out that one statement about the knife as part of this narrative. Looking at Warren, I think the only way to proceed is for the state to put on its evidence, to have the witness testify, and then when the defense wants to ask questions about other parts of the statement, I'm going to have to make a case-by-case determination as to how close in time the other statement is to the statements that the state has already put in, how much it's intertwined with them, how close it is in terms of subject matter, and whether it would be basically unfair not to have that portion of the statement introduced to put the rest of it in context or for completeness purposes. I don't think I can make an advanced ruling without hearing how the testimony comes in. And I don't think Warren or any other case that I'm aware of requires that the entire statement be put in or that the video be played in its entirety. I'm not aware of any such cases, but I welcome if you all, either of you is. So that's my position at this point, so I think we just have to proceed. Either side want to say anything further on that question?
As far as close in time, I mean, it's obvious it's close in time.
Well, I don't think close in time means the whole interview. I mean, the interview itself probably took
3.5 hours.
3.5 hours. All right. So I don't think you can say that the entire interview is all close enough in time. I think you have to look at the particular statement and how it is connected to other things that the state has introduced.
Yeah, it's like 2 pages away
You know, for example, I note that the interview starts off on page 17 where Officer Garston asks him, so what's going on tonight? And he gives a long narrative answer that ends on page 20. And interspersed in that answer, there is some discussion about these prior incidents. I mean, and I think there is an argument to be made that that is part of that statement and is intertwined with it. But then immediately after that, there's a long 10-page discussion just about the prior incidents. I think there's an argument to be made that's not intertwined with any of his answers. So it's going to be a case-by-case or statement-by-statement analysis. I don't see any other way around it. Attorney Barth, were you going to say something?
Well, if we could, maybe we can, maybe we can't get a ruling then on if the witness, Garston, says he, gave an open-ended question, what's going on tonight? Does that, from the court's perspective, invite admission of the reference to the prior incident?
I'm looking at page 23, where they're discussing the initial confrontation. And on 24, a page and a half later, they're talking about the October one. It's intertwined.
I disagree. I think 23, he's still talking about the prior incidents. He's talking about the prior incidents at that point. And that is a part of it. I will tell you, counsel, I think when I look at what is on pages 17, for example, on pages 17 through 20, where he asks him the open-ended question about what happens, and he's telling him about, he comes out, says he's going to kill me, kill my family, and I don't know who he is, and this isn't the first time this has happened. It strikes me that is all intertwined as part of his answer. And if you elicited portions of that, I think it would be fair game for the defense on cross to ask him, well, didn't he also say during that answer that there had been prior incidents? I think it's all intertwined in that answer. Now, does that also mean he can then delve into all the details of every other time he's talked about that? Not necessarily. But in that instance where it is literally intertwined in that part of his answer, about what happened that night, why he did what he did, and then he goes on to say, and this isn't the first time this happened, he did it. I think reading State v. Warren, I think there's an argument to be made it would be unfair to carve out that one little bit of that answer. So I can tell you on that one, I think that is how I would rule on that one. Now, it's a long interview, and I can't tell you exactly how I'm going to rule on the rest of them, but that's my thinking. I don't know if that changes anything.
Can I have just a quick chat?
Sure.